I think the strangest argument that Donald Trump's lawyer kept making today was this notion that somehow a president who is not impeached and convicted by the Senate cannot be prosecuted. Now, I got to say, as far as I can tell, this is an argument they appear to have basically invented whole cloth in the last 24 hours. And you can hear the skepticism from the judges.
I've asked you a series of hypotheticals about criminal actions that could be taken by a president and could be considered official acts. And I've asked you, would such a president be subject to criminal prosecution if he's not impeached or convicted?
Requirement.
And your answer, your yes or no answer is no.
I believe I said qualified yes if he's impeached and convicted first. We may be saying the same thing.
My question was, okay, so he's not impeached or convicted. Let's put that aside. You're saying a president could sell pardons, could sell military secrets, could order SEAL Team 6 to assassinate a political rival.
Okay, so the argument, just so you're tracking, the argument that Trump's lawyer came back to time and time again was that the only way that you could, under the Constitution, prosecute a hypothetical president for doing all those hypothetical crimes would be if first, while he was president, he was impeached and convicted by a 2/3 vote in the Senate. Now, there are a bunch of reasons why the argument is ludicrous, not the least of which is that when the ex-president was being impeached the second time, one of the arguments made for acquittal was that impeachment wasn't the right venue. Republican Senate leader Mitch McConnell argued at length it wasn't the Senate's job to hold Trump accountable. That's what prosecutors and courts are for.
President Trump is still liable for everything he did while he was in office. Didn't get away with anything yet. We have a criminal justice system in this country. We have civil litigation. And former presidents are not immune from being accountable by either one.
Lisa Rubin's a former litigator, now an MSNBC legal analyst. Charles Coleman prosecuted civil cases on behalf of the U.S. government. He's now a civil rights and criminal defense attorney. They both join me now. Great to have you here. Okay, first, just give me your first read on the centrality of this argument. The you have to impeach and convict first argument as it appeared today, which I was not anticipating to be as central as it was.
Well, that's because it's not their first line argument, right? The argument that they're making on presidential immunity starts with the overarching, he's immune from everything because of the structure of the Constitution and separation of powers principles. This was their sort of second line.
Fallback.
Correct.
Yes.
The impeachment judgment clause of Article 1 of the Constitution, which is really intended to be a limit on the Senate. And essentially what it says is, if you impeach and convict someone, the penalties that you can impose upon them are disqualification from holding office and removal from office and nothing further. But nevertheless, nothing should prevent that person from also being liable in a court of law. There's nothing in that text that says anything about what avenues of relief are open, for example, to the Department of Justice, which is not addressed in Article 1. This is meant as a constraint on Congress, not a get-out-of-jail-free card for a former president.
And in that way, Chris, they sort of backed their way into this argument.
I could
very
feel
much
it
so.
happening. It was like, oh, now I'm here. What am I doing?
Because, as Lisa said, this is a clause in the Constitution that is supposed to limit Congress, limit the Senate, not give the president more power. However, one of the things that I had found so interesting about this entire ordeal was I've been wondering, going into today, where are they going to create an actual constitutional question that could potentially make its way to the high court?
Yeah.
They didn't do it. I was looking to see whether in pushing on the separation of powers issue, they would create enough controversy that it might pose a legitimate question for the Supreme Court. I don't think that they did that.
So here's what I think. A very smart lawyer I talked to about this today made this point, which was clarifying for me, because I was like, what's up with all the impeachment stuff? And she said, look, it's a fallback position, right? Because what they actually want to argue, what they've argued in the briefs is, you can't do anything.
Correct.
Right? If it's an official act, tough luck, buddy, which means if he sells SEAL Team 6 to go assassinate his political rival. Now, they couldn't argue that because it's so ludicrous. So now they've got this fallback impeachment position. It's just worth playing, because this is a classic Trump thing. Like, in one venue, the argument is like, well, this is the venue. Yeah. And then you go to the other venue, you're like, well, it's not the venue now, right? They love to do this. Here's Trump's lawyer during impeachment assuring the senators, look, if you go to vote for convict, he can, of course, go get arrested and get convicted. Take a listen.
if my colleagues on this side of the chamber actually think that President Trump committed a criminal offense. And let's understand, a high crime is a felony and a misdemeanor is a misdemeanor. The words haven't changed that much over the time. After he's out of office, you go and arrest him. There is no such thing as a January exception to impeachment. There is only the text of the Constitution which makes very clear that a former president is subject to criminal sanction after his presidency for any illegal acts he commits.
That's Donald Trump's lawyer at the impeachment hearing making literally the opposite argument that his lawyer made today before these judges.
Yes. And one of the reasons it's also specious is because this impeachment judgment clause, it doesn't just apply to presidents. It applies to anybody who could be impeached by the House and Senate. That means former federal judges, for example, or cabinet secretaries. Some of those people have been prosecuted and convicted without impeachment. Hello, Henry Cisneros, the former HUD secretary. And there are a litany of federal judges who have been prosecuted and convicted either without impeachment or before they're impeached. So Trump's lawyers had to have known that during the impeachment debacle that you just showed there. They understand full well that the impeachment judgment clause isn't just about the president. And those real life examples show why it can't possibly be victorious here.
I guess the question for you, right? So I thought when the impeachment thing showed up in the brief, right? So in their brief, they had this again. I mean, it's a little like taking a shot from 36 feet. Like, you know, if you hit it, great. But like, you got to try, right? So it's like they had this thing about like it's double jeopardy because he was already impeached and wasn't convicted. And so criminal trial. And that's like that's sort of fallen by the wayside a little bit, but they've refashioned it. I guess my feeling was like, are they trying to come up with something novel enough that SCOTUS will take it?
I
this
think
thing is so out of nowhere.
Correct. This entire ordeal around impeachment, this entire question, this entire appeal is the shot from 36 feet. It's actually the half court. It's actually the half court shot. Really, like if it goes in at any point for any reason,
you take it.
You take it. And I think that the more that you can jam pack into that, you may get a line. It might be what we refer to as dicta in an opinion that you try to sort of ride. And dicta is something that a judge might say that's not necessarily germane to the case, but is part of a decision. They're looking for something that they can hang their hat on, some door, some avenue, some crack that they're going to be able to open that's controversial enough that they feel like it's going to generate a legitimate question for another appeal for more delay.
Okay, can I ask you a quick question on timing?
Yeah.
That Harry teased, right?
Yeah.
There's a back and forth about the possibility of some sort of remand. What did you make of that?
Well, I think it's because in the civil context, this same court recently decided an appeal with respect to 3 cases brought by former police officers, members of Congress who have sued Trump civilly. And in that case, the civil rule is that a president does have immunity within the outer perimeter of his official duties. Because of that, they sent it back to the lower court to determine, well, what was he doing here? Was he acting in his official capacity or some personal capacity? That makes sense where you're talking about the civil rule. But here, the court has to fashion a rule in the first place, right? Correct. Judge Chutkan's lower court decision says there is no criminal immunity of any kind. So it's unclear whether they'll need to remand at all. And they're supposed to take these facts as true.
All right. Charles Coleman, Lisa Rubin, that was great. Thank you.